I guess I'm just saying that if you take away the elements that make life possible, then you have deprived life. And so we have to be mindful of those things, and we also have to be more than legalistic about things. Rather than just look at what's in black and white, we have to understand what it means to have rights. If we have a right to a healthy environment, and we also have property rights, and I believe we have both, arguments will be made that we don't have the right to stop someone from making money because they enjoy, say, ownership of a deed or a title or mineral rights or something like that. In general, I would never want to suggest that someone can't benefit or profit from having their property, owning their property. But we as communities, as governments, local, state, and federal, we also recognize that there are limitations on how we can enjoy our property. We can enjoy our property in many places where we're also limited, say, on whether or not we can burn old tires in our backyard. Why is that? Well, because even if I have the opportunity to import a lot of old tires and burn them and I can make money, and that's my living, it's my proposed living, the community understands and the government understands that allowing that to happen would likely result in a violation of the rights of the people in the surrounding community. And so we have to weigh, in some cases, we have to compare what's the higher right, what's the real crux of the matter here. Someone's right to, in a short term, create some income, or in the long term, the health, safety, and welfare of the community, and the livability of the community, and the quality of life, and all of those things. So tough decisions have to get made. Fracking could be put into that category. If I own land, and if I sit on top of a shale deposit where there's natural gas down below, do I have an unchallengeable right to access it by any means? Well, I'm not here to tell you yes or no. That's not my job. My job isn't, I'm not even here to tell you that fracking is good or bad. That's not my job. It's up to each community to decide for themselves, in my view. It's up to the people affected by governing decisions to make them, or for their representatives to faithfully create the outcomes that the community wants if we're going to have representative government. I mean, that's what has to happen. I'm from North Middleton Township, Pennsylvania. That's where I have a right to have that kind of input on local issues. If you live here in Youngstown, I would suggest this is where you have a right to have that kind of direct impact and decision-making authority. That seems to me what democracy and representative government is about. So you have some options. And again, we don't sell our ordinances. We're a nonprofit. We offer our services for free. Just for full disclosure for City Council and everybody else here, we don't charge for legal services. We write the ordinances based on conversations we have with folks in the community. We start out from a particular perspective that we're going to start with building on a community bill of rights. That's what we offer. That's what we do. If a community doesn't want to do that, then they don't seek out our services. Full disclosure, yeah, I actually asked for reimbursement for my travels because I drive my own car and I'm all over the place, so I just had to buy new tires, so it helps when you're a nonprofit. We're not real deep-pocketed either. So to be clear, we're not offering financial services, we're offering legal services, consultations, things of that sort. You have some options in front of you as a community, and I say that you, collectively, everybody in the room, which is how I prefer to see the communities that I work with, not just as municipal corporations, which were by and large set up by the state, and there's a whole history from state to state. There are differences on how that happens. But looking at you as a community, and in terms of the issue of fracking, you have the option of doing nothing. That is an option. And I don't say it flippantly, and I don't mean to say it even judgmentally, because it's your community, not mine. What I would say, though, is if you decide to do nothing, if you just say, we're going to let things roll, whatever the state says, that's how it's going to be, then there are certain consequences. You know, I can predict what some of the consequences are. You all can do the same thing. Whatever the case may be, I would suggest that if you do nothing, you're going to have some negative results that are going to have a negative impact on your quality of life in one way or the other. And if nothing else, you'll have a definite, immediate impact of not having a democratic process in terms of that question. So, but that's still an option. And in any given community, people might say, well, I don't have the time. I'm too busy. The kids got me busy. I can't do it. You know, can't be involved. Clearly, in this community, there are a lot of people who are willing to go well beyond that and get involved in one way or the other. But if you decide to do nothing in the end as a community, there will be outcomes, and the people living today, I would say, need to take responsibility for those outcomes. We won't be around to answer future generations, but we kind of should be. Second option of three, try to make existing law work as well as you can, which is what the advice you usually get from law departments, from municipal solicitors. Every community I've been in, there's been advice from the legal department, the solicitors, so forth, that the best you can do is use the law that's on the books. Nothing else is permissible. And I understand where that comes from, and I don't want to demonize the people that give that advice. They were hired to give that kind of advice. So just to be fair, everybody, you know, as we're looking at the reality of the situation, we're the adults in the room. We have to understand who's responsible for what. But in each situation, different people are responsible for different things. So if we decide to stick with the existing law, try to enforce the regulations on the books, and then we look and we say, wow, looks like in this case, this industry has been not only deregulated, they've been made immune from the regulations. Now, when an industry or an individual is immune from law, if they've been given a pass on, say, the Clean Air Act, the Clean Drinking Water Act, the Superfund Act, as the fracking industry has, that's federal laws. What does that mean? It means not just that they got a pass, it means that they're above the law, because all of us actually have to obey those laws. So, I mean, we have to start thinking, I believe, what we're up against. And that explains a bit why proposing a community rights ordinance seems to make a lot of sense. The third option is to assert our rights, to say, unlike in the first two options where we do nothing and we say, well, we'll just try to do what the state says we're allowed to do. In those two options, we've conceded that we don't have the authority or the right to protect ourselves, to just say no and to say health, safety, and welfare of this community actually is superior law to environmental regulations and zoning. I mean, think about it. How do we have the temerity to suggest that a little local ordinance can actually challenge state or federal law? And the answer is neither the state nor the federal government have authority or legitimacy directly themselves to violate rights or to issue permits, licenses, or corporate charters to third parties, empowering them to violate rights. So, it's not about just being defiant and just saying we want to have our way. It's not about, as I've heard often enough from corporate folks, well, those folks are working from feelings and emotions, and they need to dig into the science instead. Feelings and emotions, like being protective of our children and of our environment and caring about the future of our community, those feelings and emotions are what have driven democracy for a long time. They're good. Another word for them is values. There are other feelings and emotions that aren't usually characterized as such. The drive for acquisition and gain and profit and wealth. They don't come from science. They come from certain very human, and we all have them. It's not to pick on anybody particular, but advantage over the rest of your neighbors can be an emotional drive too. We have to be honest about that. The ordinance in front of you is about asserting rights instead of conceding that you don't have them. It's about saying we realize, and with all due respect, that the state generally can regulate as long as they're doing it responsibly and not in a way that violates rights, that they have the authority to set certain standards. What we have instead of standards that are protective of the community, in terms of regulation, here's how it works. And I'll finish up soon. I'm probably running well over, I don't know. But think about how the regulatory system works. EPA, state regulatory agencies, whatever. They set a level of what's considered to be legal on various matters. And I use just the shorthand of, say 10,000 parts per million of toxin X. That's legal to put in the water, but no more. How do we know that it's legal? Because generally the state issues permits that allow the industry to engage in that activity, and so long as they don't exceed that legalized maximum harm, they're within their rights to put that much toxin in the water. In other words, the permit is a license to do a legalized level of harm, but no more. And then preemptive law comes along and adds to that and says, by the way, 10,000 parts per million of toxin X, that's legal. And no city, town, village, township, county can pass a law that makes it illegal to put that much toxin in. That's the legalized amount. And so it's not like they're saying we're going to be protective of the community and we're going to hold that protection as the highest good. What they're saying is that's the maximum amount of protection you're legally afforded. And if you attempt to protect yourself any more strictly, you will be breaking state law. I had a hard time with that for a lot of years. It didn't make sense to me. It seemed to me, because I really believe that we should have a government that represents the interests of the people, it seems to me that if the bottom line was we need to protect communities, members of communities, then we would be saying 10,000 parts per million. Maybe that's in good faith. We think that maybe that's okay at the state level. But just in case, if you in your community say, in your best judgment, you don't think exposing your families and your future generations to that level is a good idea, then you retain the authority as self-governing we the people to put in place more protective regulations. In other words, wouldn't it make sense if the state simply said, this is the minimum amount of protection that must be afforded? The minimum, not the maximum, the minimum. Given that they say it's the maximum instead, whose interests are protected? Is it the citizens of Ohio? Or is it the industries that want to do business in your communities? In other words, what I'm suggesting is that much of state law and preemption protects industry against democracy, because allowing the people to use their own judgment and decide for themselves what they think is best for themselves in their own communities is intolerable, apparently. So, an ordinance like this, I'm not going to lie to you, it challenges some stuff that I've been talking about. It really does. It does challenge some things. It challenges the notion that corporations can be afforded privileges that can set aside human and civil rights. It challenges the notion that even if law is illegitimate, you can't do anything about it. If that's where we've arrived at, we have arrived at a bad place in our history. So, I'm sure you have lots of questions. I could say a lot more, but maybe I'll answer some other things as we go with the Q&A, okay?
Thank you, Ben.
Thanks.
As we move into the question and answer section of this meeting, just want to explain to some, we have a lot of visitors here, and just how the rules of council work, how the rules of our committee work. You can only speak when recognized by the chair, and you're speaking through the chair of this meeting, which is myself. We are going to entertain questions first from the committee members that are seated at this table. John Swires is the chairman, TJ Rogers is a member of the committee, and then our council members. And for the record, Janet Tarpley, the 6th Ward Councilwoman, is here at the meeting. We also have Annie Gillum, 1st Ward, and Nate Pinkert, 3rd Ward. Also, when we do recognize you to speak, if you'll come up, if you're in the audience, to this microphone here on the corner and state your name clearly for the record. And the only questions we will be entertaining today at this meeting are questions pertaining to this rights-based ordinance and directed towards Ben Price. We're not debating or answering questions about fracking, whether it's right or wrong. We're only talking, is information about this ordinance and rights-based bans as they pertain to this ordinance, just to be clear. Because we do have a limited amount of time. I want to make sure that we get as many questions answered as possible. John, go ahead.
Yes, through the chair. Just to satisfy my curiosity, how many people out in the audience, if they can raise their hand, actually are currently a resident of the city of Youngstown? Very good. Okay, very good.
Thank you.
Thank you.
I do have a question on this, Ben. I guess some of the language, I guess this is just a draft, but
sure,
some of the language does seem a little inflammatory, and I guess there, generally a law would be a little more benign in nature, but again, that's housekeeping and doing some work in preference. Sure. But some of the things on there, we don't address one thing that was a hot topic in here, and I don't know if it's just a matter of injecting some language, injection wells.
I knew you were going to say that. Thank you, Councilman. Yeah, actually, and as I looked at it recently, this was put together originally, I think, in April through our conversations. I would actually suggest, and it would be the insertion of another paragraph, and that would be, if I'm not mistaken, Section 5. No, not 5, 4. In Section 4, we have the prohibitions and so forth. We have any number of communities that have adopted similar ordinances that include prohibitions on injection wells, and they go even further, just to be clear, that some have gone further to say they ban establishment of infrastructure related to fracking. Some more specifically ban withdrawal of fresh water from anywhere within the jurisdiction for use in the fracking, because even if you banned it and if they honored that, they might come in and take your water from the rivers or whatever. So that type of thing could certainly be inserted into it very quickly because we have the language already developed.
Okay. Also on, I guess, page 1, the second to the last paragraph before section 1 starts, we talk about your language has nullifies state law. I guess I've been advised the dangers of, nullifying, and there's maybe other ways to say that. Nullification language could be, or nullifying could be.
Words can be changed, yeah. And nullification is, I know that in certain contexts it has a really kind of a connotation of being radical or whatever. It was actually Thomas Jefferson who originally brought up the idea when it came to the Alien and Sedition Act that John Adams as president proposed, which was shutting down newspapers and so forth that were critical in any way of the government. But yes, can that language be changed? Absolutely. But just to be clear, because this is about challenging state law, not to be just challenging, and it's not to be just confrontational, but laws that illegitimately violate rights or empower a third party to violate rights. It is, in a sense, about nullifying them or at least challenging them, if you will. So I think that language can be changed even to say challenge.
Okay. John?
Yes, through the chair. Has anybody out in the audience been down to the state legislature, to any one of the committees that would be an oversight of this, and spoke about some of the things that are in this proposed resolution or ordinance? Has there been anybody that's gone down to the state, to our legislators? Yes. What's that?
315 section.
Oh, okay.
You couldn't go down there and
Thank you. Just, yeah, and I think what John is saying in the spirit of that, the regulations in Ohio come at a state level, and, also aside from lobbying your local government, the importance of making it your voice heard at a state level with state legislators. And I don't know, in your experience working with these groups, if there's any, if they respond to that, or if any changes have been made by lobbying.
It's a really good question, and anyone who's been involved at all with trying to affect outcomes locally has probably gone to the state legislature. And we certainly have in Pennsylvania. Lots of folks are doing so in New York, and I'm sure here in Ohio as well. The problem seems to be that the average citizen doesn't have the ear of their state representatives in any real way. And that's not said with any glee. It's said, we're disheartened about it. And so how do we get their ear? And quite honestly, this ordinance, we don't irrationally expect that just because a few cities or towns adopt community bills of rights that will solve the fracking problem. Let's be clear what this ordinance is. It's an assertion of rights. In the communities that have adopted these ordinances so far, not one has been legally challenged, which is interesting.
No, but I mean, that doesn't mean they cannot or they will not be challenged.
That's my next
clear
point.
On that. I mean, it hasn't happened yet.
That's my next point. That does not mean they won't be. It means they haven't been so far. Now, I can speculate on a couple of reasons. Some are, more interesting than others, but, maybe they can frack other places. Why stir the pot, right? Why stir up the bee's nest? These people seem to be, serious about it. The other is these ordinances are crafted in a way that they're intended to raise rights to the level of the discussion that we're having about fracking. And it's not a discussion that the industry wants to engage in. Consider what it would be like, and this is an exaggerated hypothetical, but imagine a drilling corporation wanting to challenge an ordinance of this sort and having to go to court to make the case that, oh, Your Honor, these rights, the people don't have those rights. Oh, but we do have our rights to drill. It's not the best PR platform. It's when they're spending millions on TV commercials to put a smiley face on the industry, it's not the best PR platform. Where did you start with your original question, though?
We're discussing state.
The state.
Yes, to go to the state.
Actually lobbying at a state level.
Now let's consider the other aspect about these ordinances. we do want the state to change law at the state level so that community after community doesn't constantly have to fight these battles. It doesn't mean that this isn't about trying to create little city-states, throughout the state. It's not trying to make sovereignties with no answerability to the state. It's about drawing a line and saying the state has certainly authority here, but it doesn't have authority to impose activities that violate rights. Now, if we want that to actually be acted on at the state level, how do we get there? One way might be is if we had a real movement of municipalities, representatives of constituents working together as a team, standing up to the state legislature saying, we can't get your attention any other way, so we're going to do this. This will get their attention. It may create the opportunity to have the big conversation that's needed, which is, how come we don't have any rights, or how come we don't have the right to determine the future of our community? There's the people kick around the idea of sustainability. It's illegal to create a sustainable community under current law. It's illegal because in so many aspects, so many ways, for you to try to attempt to put together a sustainability policy on any given issue, whether it's energy sustainability, agriculture, water, whatever it might be, for you to actually, as a community, put policies like that in place, chances are you would be running afoul of the interests of some large corporate interest.
Well, that'd probably be a good conversation for us to have. We do have the, the luxury of having the Northeastern Ohio Consortium on Community Sustainability operating with 12 counties of Northeastern Ohio. So,
Now, if the idea is to empower that, those aspirations so that you can actually get the outcomes. Whatever organizations we put together, if we don't challenge the idea that legally you can be forced not to create those policies because it violates a corporation's rights or whatever, or it violates state preemptive laws, if we can't get past that, it doesn't matter pretty much how many meetings we have or what kinds of organizations we form.
Thank you. TJ, John, do you have any?
Just piggybacking on this conversation that we're having about, the state, it wasn't too long ago that there were labor and union laws, and I know this is a little different because now we're talking about EPA things that were forced upon us that a lot of people didn't agree with.
Right.